AIG Europe Insurance Limited.
Yes, Mr. Callan.
My Lord, in this matter I appear together with my learned friend Miss Claire Dixon for the appellant AIG Europe Limited. My learned friend Mr. Timothy Dutton QC, Mr. Richard Chapman and Miss Pia Dutton appear for the respondent Impact Funding Solutions Limited.
Yes.
The issue in this appeal, as your Lordship will no doubt appreciate, is whether the liability of a firm of solicitors to a commercial lender whose loans to the solicitor's client are guaranteed by the solicitors falls within the scope of the solicitor's professional indemnity insurance, or whether it is excluded from cover. Now, the point is quite a narrow one, and it comes before your Lordship's court because, in our submission, not only did the Court of Appeal get it wrong, but it is so in a way which had implications beyond the particular decision.
Yes, we see that. Well, we agree with you that it looks quite a narrow point, and we're grateful to you both for dealing with it comprehensively but not too lengthily in your respective cases.
I was taught by my Lord Assumption many years ago to keep it down to 5 pages, and I only managed 9.
Perhaps we should have a rule like the European Court does, but perhaps that's now no longer relevant.
My Lord,
how many other cases is this going to affect? I mean, it's obviously quite an important sort of standard model of contract. I mean, are there a lot of other...
There are a number of other cases where either the present respondent or its sister company, Sutherland Professional Funding Limited, have claims against solicitors, insurers, or solicitors, and through them their insurers. There's a number of those, but also the implications for the exclusion clause, what's called the trade debts exclusion clause, are wider because
very standard exclusion.
It is the standard clause subject to minor tweaking in solicitors' professional indemnity insurance policies going back a number of years, which can't be changed. Whether outstanding claims, and it's going to be this clause, I believe, for the next year, the way things stand.
Yes. Right. Well, as I say, we've got the points, and we've seen that you've also given us some instruction on principles of construction, interpretation, exemption clauses. I don't think that we feel it particularly necessary for you to elaborate them orally in court, unless there is some specific point. It seems to us at the moment that it's really a question of, first of all, categorization, whether this falls into the category of contracts of services, and secondly, whether that's the end of the matter. I think it's suggested, Mr. Dutton says, even if it is a contract of services, nonetheless, this isn't the type of claim, bearing in mind, I think he argues that it's effectively the mirror image of a claim which could have been made in other circumstances by the client, which can't have been intended to be caught by an exemption-headed trading debts or an exemption in respect of breaches of contracts of services. So if that's the right sort of outline of the issues, I don't think you really need to develop the basic points of
all I was going to say about construction of contracts, my Lord, was I won't take your Lordship's to it. An Ireland and Britain in Lord Neuberger's speech or judgment, he emphasises the importance of the words the parties have chosen to use. We're going to say that maybe it's a basic
I think
point.
we're not going to be keen to go around that particular block again either, because I mean, there are quite a number of authorities if one was going to.
Well, in our submission in due course will be that the Court of Appeal lost sight of that rather basic principle.
Yes. Well, obviously, everyone agrees you start with the words which are used.
And on the contra preferentum point, I will not go into it and develop it at this stage, but just so it's clear what our position is. First of all, the rule only applies where there's an ambiguity and none has been identified.
Yes.
That's our first point. Our second point, there's reliance placed on the Court of Appeal decision in Tectrol Limited, an international insurance company of Hanover. That was concerned with the meaning of particular words in exclusion clauses, particularly malicious persons in one limb and loss in another. And it was held that those words took their meaning from the words around them. In other words, there were different interpretations of the words, and the Court of Appeal, I think perhaps with my Lord Carnworth dissenting on one point, held that they were narrow because of the context. But again, there's no attempt here to show a word which has a wide or a narrow meaning.
Well, I was going to say, I mean, we're concerned with categorization. What is a arrangement or contract for the supply to or use by any insured of goods or services. And I mean,
Well, I will move on. I had a short version and a long version.
yes.
And
Carry on.
I've even shortened the short version. But the third point was going to be that the respondent does confuse two different things. I could make this clear. One is, how do you ascertain the meaning of the clause? Is there an ambiguity in that? And the second thing is there a difficulty? Is it a difficult or not straightforward task to apply it to the facts?
Yes.
And the example we were going to give is the fraud and dishonesty exclusion, where the test is a legal one. It can be a very difficult question to decide whether a particular solicitor has or has not been dishonest.
Yeah.
But that's a 51% burden of proof question. It's not contra preferentum.
Yes.
That's the point we make.
No, I mean, the only area where contra preferentum could conceivably come in, it seems to me at the moment, is the second area, assuming this was a contract or arrangement for the supply to or use by any insured of goods or services. Nonetheless, is this the type of claim which was intended to be excluded by this clause? Because one can see, as the Court of Appeal did, many different types of liability under a supply contract, which clearly wouldn't be appropriate to be covered, but it might be argued that this type of liability, if it really is the mirror image of a claim which a client might have had in other circumstances, is the sort of claim that was intended to be covered. So it's only on that area, but again, I'm not sure how far contract preferentum is going to help us on that.
No. Well, I'm going to move on, if I may. My proposed route is now to take the court to some of the terms of the contract of insurance.
Yes.
And then discuss what they mean, and then go to the contracts, the underlying disbursements funding master agreements, or DFMAs, and take the court to some of the provisions of those and the related loan agreements, and show how the scheme worked, and then say why we and the judge at first instance were right, and then why the learned friend and the Court of Appeal were wrong.
Yes.
That's a route map. Can I take the court, if I may, to the contract of insurance, which is in tab 11 of the core volume, or page 213 of the electronic bundle. I don't see anyone working from that much. I'll give both references, but it's headed Solicitor's Professional Indemnity, Solicitor's Professional Liability, and this is AIG's policy. Behind tab 12 are the minimum terms and conditions prescribed by the Solicitors Regulation Authority, which has to provide at least that cover. Perhaps we should start with those at tab 12, EB, Electronic Bundle, page 236, and they're headed the minimum terms and conditions of professional indemnity insurance for solicitors and registered European lawyers in England and Wales. And they require, at clause 4.11, at page 236 of the core volume and page 241 of the electronic bundle, clause 4.11, the insurance must provide that the insurance is to be construed or rectified so as to comply with the requirements of these minimum terms and conditions. Any provision which is inconsistent with these minimum terms and conditions is to be severed or rectified to comply. So if you depart from this wording, it's a one-way bet in favour of the insured.
Right.
Because you can only give more extensive cover, or in the case of exclusions, lesser exclusions. Then going back to the policy, which does not adopt the exact wording of the minimum terms, the insuring clause behind tab 11 at page 216, or page, 211, 216 of the electronic bundle, it solicits professional liability cover, and it makes clear it's a claims made policy, and then says this: professional liability, the insurer will pay on behalf of any insured all loss resulting from any claim for any civil liability of the insured which arises from the performance or failure to perform legal services. And the words in italics are defined, and legal services is defined at page 213, or EB, page 218. Unfortunately, this policy doesn't have numbered clauses, but it's legal services towards the middle of the page means the provision of services in private practice as a solicitor or registered European lawyer, and then it has including various things. It's a wide definition. And the result of this insuring clause is it's extremely wide, in that it mirrors the insuring clause under the minimum terms and conditions. So the scheme of this policy is a very wide insuring clause, although it's headed solicitor professional liability and it's mirroring or trying to mirror the solicitor's minimum terms and conditions for professional indemnity insurance. But then it's subject to a large number of exclusions, which are permitted by the minimum terms. They aren't compulsory, but it's, in my experience, you never see a policy of solicitor's indemnity insurance without them in, because they're quite important to keep it down to professional indemnity insurance, properly understood. And they appear and start at page 216 of the core volume or page 221 of the electronic bundle. And I was going to just take the court briefly through the other ones so that your Lordship can see how broad they are and how they are also designed to preserve, not to exclude liability to the clients and quasi-clients of the solicitors. So it starts with, at page 216, exclusions. This policy shall not cover loss in connection with any claim or any loss, bodily, psychological injury arising out of, based upon, or attributable to bodily injury, which includes death under the definition, other than psychological injury which arises from a breach of duty in the performance of or failure to perform legal services. So claims, for example, that you suffered distress and inconvenience, or that you were, the purpose of the contract was to protect you from a condition of stress, and are preserved and carved out because they are genuine claims by clients or quasi-clients which would normally expect to be covered. Then there's D&O liability. Then employment breaches and discrimination, because that's a liability which could arise within the insuring clause. Over the page, fines and penalties, fraud and dishonesty. And then towards the middle, partnership disputes, because that could be a liability that arose out of private practice. Prior claim, which is more to do with the scheme of the a claims made policy. Property damage, arising out of, based upon, or attributable to property damage, including property occupied or used by the insured in connection with the insured's legal services, except liability for such damage, destruction or loss which arises from breach of duty in the performance or failure to perform legal services. So again, although I struggle to think of how a solicitor acting for a client in a normal situation could cause damage to physical property, that is excluded from the exclusion. Then we have the trade debts one, which I shall come back to. Then there's war terrorism, which has a whole sequence of things which are excluded. War, terrorism, warlike, military, terrorist or guerrilla activity, and so on. And then that is subject to an exclusion at page 218, just before the word claims in big print. This exclusion will not apply in respect of any loss resulting from any claim, any civil liability of the insured which arises from a breach of duty in the performance or failure to perform legal services, etc. So again, I struggled to come up with an example of how a solicitor could cause loss through war through giving advice to the client, but it may be that...
Loss to what?
Well, claims arising out of or based upon war, rebellion and so on. I suppose if you advise that a marine insurance policy covered an oil tanker in the Gulf in a war, and it didn't.
Yes, this is, yes, and I suppose in relation to property damage, you can see how solicitors to a trust could be responsible if they fail to give advice relating to the care of the property, trust property, I suppose. Anyway, that's all.
There it is. So that is what the scheme is, some very broad exclusions from the broad insuring clause, but always careful to preserve the true liability of the solicitor to his clients or quasi-clients, I put it that way. Now we come to the trade debts exclusion itself, and we only rely upon the second limb, but we suggest it's helpful to read it as a whole to see what the parties intended. And the first limb is attributable to any trading or personal debt incurred by an insured, and that we submit is intended to be comprehensive. A personal debt might well be, for example, a new partner might owe money for his share of the partnership capital. They might guarantee the loan of an LLP. And those might be personal debts, arguably, but they would be excluded from cover. We submit that's designed to be comprehensive, and there's no third category of professional debt. Second, the one we rely upon, breach by any insured of the terms of any contract or arrangement. So again, widely cast. It's not just contracts, but arrangements, and any contract or arrangement, for the supply to or use by any insured of goods or services in the course of providing legal services. And the focus there is not upon the term that's breached, but upon the nature of the contract. That's a very important distinction. It's not what term have you breached, but what is the nature of the contract. And then the third, guarantee, indemnity or undertaking by any insured in connection with the provision of finance, property, assistance or other benefit or advantage, directly or indirectly to that insured. And again, these are wide words. Assistance or other benefit or advantage, directly or indirectly, again suggests that this is intended to have a wide import. Now, I will come back to that point. We say the meaning of the clause itself is clear and unambiguous, subject to the point my Lord has made about whether it's ousted by the fact that this was in fact an obligation mirroring or duplicating that owed to clients. And that's the point that I come to when I've gone through the contract as well, the DFMAs. And there is no reason to cut down the scope of it. It's consistent with the clause as a whole, subclause 2. It's consistent, in our submission, with the scheme of the policy, which I hope I've shown your lordships, which is a wide exclusion clause, but then great chunks of liability, employment, property damage, personal injury and death, and trade debts and liabilities are taken out of the cover to bring it back to the heading, which is professional liability insurance. In the Textrol case, the insurance was all risks, and my Lord Calmer said in the Court of Appeal, well, the starting point should be, if it says all risks at the top of the policy, you're expecting it to cover all risks with small exclusions. Here we have a slightly different situation. We have professional indemnity insurance, but then a very wide insuring clause, which is much wider than the headline, and then you see how it's cut down. It may not be, it's a way of drafting it, and it's the way they've chosen.
And the heading trade debts, is that of significance? Or?
Well, it's not limited to trade debts because it's in the minimum terms, but it follows the term very closely. It's described as, I'm sorry, they're in a different order there. It's at page 238, tab 12, or electronic bundle, page 243, debts and trading liabilities. And then the wording
yes,
marches.
but you could see the first of the three, trading or personal debt.
Yes.
The heading cannot cut down that.
It can't, my Lord, it can't. No.
Why, just as a matter of interest, looking at the third head, which you don't rely on, why not? Why, on your case, wouldn't this be a liability arising out of an undertaking by an insured in connection with the provision of assistance or other benefit or advantage, directly or indirectly, to that insured?
It would have been if Impact had pursued their first head of claim.
Yes. Well,
Impact pleaded their case first under Clause 7, which would have run them straight into the problem identified by Lord Mads. But they didn't pursue that to judgment. They obtained judgment only for breach of contract, and that brings you, therefore, to 2, which is a breach of a contract exclusion.
Well, doesn't breach of contract arise out of an undertaking by the insured?
Well, rightly or wrongly, well, we argue in the Sutherland professional funding case, which we will come to later on. That was solely under the equivalent guarantee clause of 7.2.
Right.
And His Honour Judge Hegarty, Queen's Counsel in Manchester, found that it fell foul of actually 1, 2 and 3. But 1 and 3 were both in play because it was a claim for a fixed sum, so it was a debt. And 3 because it fell within that as well. Here, the claim is based upon breach of a warranty that the insured solicitor would exercise reasonable skill and care in conducting the claims. And so it doesn't arise out of a guarantee.
No, but it arises out of, well, what's the difference between a warranty and an undertaking?
I did wonder whether to try and sneak that back in again in this court, and I didn't, my Lord.
I see.
If I succeed under 3, I must succeed under 2, I would say.
I mean, it may be that it doesn't make much difference, because the supply of a benefit or advantage to an insured is normally the supply of a service, one would have thought.
Yes, well, there is some wordplay between us, whether if it's of service to us, well, that is a service, or whether it's of benefit to us, that is a service. And it seems to be accepted there's at least an indirect benefit out of these arrangements. But it's said that's not enough to be a service. I will hope to beg your lordship that it's both of service and a service, if there was a difference.
Yes.
But that's the clause.
It was dealt with by His Honour Judge Waxman, was it?
Yes.
The third point.
No, he dealt with subclause 2 only. Judge Hegarty in the Sutherland professional funding case did all 3.
I see.
Before Judge Waxman, we relied upon subclauses 1 and 3. Our case was, in part, that the primary cause of liability, or a concurrent, equally effective cause of liability, approximate cause of liability, was clause 7.2, and that was excluded, and we should rely upon that. And that argument failed, and we did not renew it in the Court of Appeal.
And you didn't renew the argument based on little 3 of trade debts.
So that only arose, and our argument was that liability under clause 7.2, guarantee liability,
yes, I see. Yes.
was a concurrent proximate cause, or the proximate
Yes, no, I've got that point.
and that was excluded, and therefore the Wayne's tank and employers liability,
Right.
Miss JJ, 2 effective causes.
They didn't ultimately seek judgment under clause 7.2, did they?
No, they proved in the liquidation, I believe.
Yes.
But it's the
It's
same
like
teams both in the Sutherland case and effectively for the claimant in the Sutherland case, not for the solicitors, and in this case. And in the Sutherland litigation, they then tried to amend to bring in a claim under the equivalent terms as clause 12.13.
Slightly unsatisfactory that we can't consider the whole clause. These are all points of law. But you don't appear to have argued ever at any stage in this litigation that 3 independently was an alternative, possibly even a better alternative to 2.
No. No, I was making the point that we say it's this wide approach to the clause, including little subclause 2, is consistent with the scheme of the Act. We say it's also consistent with the purpose of compulsory professional indemnity insurance for solicitors. And the source of the power of the Law Society now exercised through the Solicitors Regulation Authority, SRA, is Section 37 of the Solicitors Act 1974, which is in the authorities bundle at tab 1, page 4, or the electronic bundle at page 375. And it gives the society the power to prescribe insurance and various powers pursuant to that. And that power was before the House of Lords in the case of Swain against the Law Society in the days of what was the master policy, when there was a perhaps rather enterprising challenge by the solicitors to the fact that the Law Society had set up a brokerage to affect the insurance policy. And I would, if I may, take your court to...
What do we need, Swain?
Oh.
What's... I mean, everybody accepts that the scheme is one which there's a statutory power to impose, and it's those clauses were adopted in your policy, and we've got a question of construction.
Yes. Well, it's just to say this, that what's said in Swain and the Law Society, and also by Mr. Justice Thomas, as he was in Kumar and AGF Insurance, which are in our case, is that the purpose, or the primary purpose of this enactment, was not to protect solicitors against claims, but to ensure that their clients, those who used legal services, would find that when they sued, the cupboard wasn't bare.
Well, that's the purpose of compulsory insurance, certainly, but or primary purpose, but can't be the only purpose. I mean, professional insurance also protects the insured.
Well, it does, but the power. Our submission is this: that the power to do this is focused upon protecting solicitors against claims by their clients or quasi-clients.
Yes.
That's what the power is there for. It also therefore protects the clients to an extent, and that is why it is compulsory. A solicitor might be advised to have wider insurance. For example, if one takes the exclusion for employer's liability, they should have insurance against employer's liability under a different...
Yes. You mean there's no public policy really to ensure Impact Funding Solutions Limited?
That's the point, my Lord.
Yes.
We say that it's these exclusions, particularly the trade debts exclusion, so-called, but 1, 2, and 3, are designed to take out of the professional indemnity insurance liabilities which do not need protection. And the SRA and the Law Society, by allowing them to be taken out, are saying we don't need to use our Section 37 powers to protect you against that sort of liability. There's a further point, my lord, which is this, that the wider the insurance is, the cover is, the more it costs. And cost of professional indemnity insurance is a material concern to many solicitors. There's been SRA consultations about it, because and there is a balance to be struck always between the extent of cover and protection both for the relevant section of the public and for the solicitors themselves, and the cost of the insurance, which has to be met out of the solicitor's fee income and therefore impacts on fees. And therefore there is every reason, we say, to give natural effect to these words, because they've been designed in a way to make sure that there's not compulsory insurance for risks which don't need to be insured against compulsorily. Well, that was all I was going to say about the policy wording at this stage. I was going to take the court next, if I may, to one of the disbursement funding master agreements, which is behind divider 8 of the core volume, or e-bundle, page 144. Now, somewhat unhelpfully, this is not the one that was referred to in the Court of Appeal. So what was clause 13 in the Court of Appeal is now clause 12. But the reason I've gone to this one is it has a schedule attached which is missing from the version of the other one behind divider 9. But there's no other material, there's no material difference between them.
So are we at manuscript page starting 140?
140, I'm sorry, yes.
There is a difference, because clause 13 is different in that from the DFMA that follows.
Well, clause 12 has become, in the other one, is now clause 13.
Oh, I see.
And what's happened is there's a new, if your lordship were to look at schedule 2 at page 151, ED 155.
Yeah, so
Schedule
clause 12 in number 8 becomes clause 13 in number 9.
Yes. Schedule 2 at 151 has turned into a new clause 8 at page 159, EB page 164. So they all go back one to accommodate schedule 2, and that's what's happened. That's the change. So otherwise the wording is materially the same. So that's why I've gone for the different one. Although I've gone for the different one because it has, schedule 1, it sets out some figures and amounts. Not schedule 1, I'm sorry. Schedule 3. Can I start at page 140 of the paper bundle and 144 of the electronic bundle, the various definitions, and advance, which is the third one, means a loan advanced by the respondent to or on behalf of a client under a credit agreement to finance disbursements incurred by the firm on behalf of the client in respect of a PI claim. That's what the advance is. But they're disbursements incurred by the firm, that's the insured. And then over the page, disbursements means expenses and disbursements incurred by the firm on behalf of the client. This recognises what we say the position is at law. A solicitor is personally liable for disbursements with a right to recover from the client, absent anything else. And this is recognising what is the position.
what you wouldn't normally get, presumably, with a client relationship where there was no funding company, would be large advances of disbursements in respect of disbursements which hadn't yet been made.
There might be, it's not been unknown in the past for solicitors' firms not to be in funds for counsel's fees, then find that the client disappears.
Yes. Yes, well, that's...
They wouldn't normally have paid the counsel
Yes.
fees at that stage, but
Whereas the odd...
issues have arisen, in my experience, not personally, of that happening.
Well, what's the balance here? We know that Impact Funding Solutions funded disbursements which had been incurred and then produced a further sum for future disbursements. What was the balance in percentage terms between...
The impression, the scheme is that if there were if disbursements had been incurred already at the time the loan is made, this is the next clause actually, then the solicitors can direct the respondent Impact to pay directly to the people to whom the money's owed.
Right.
What's owed. And the balance goes to their client account.
How much would the balance be in percentage terms?
In practice, as far as I can see, Impact didn't incur disbursements before the loans were made. It may be they should have.
I see. So in practice, the whole lot just... And how was the loan calculated? How did you calculate...
Perhaps I can show your lordship. It's page 149 of the paper bundle, page 153. It was done through the veracity system, which is operated by a sister company of the respondent, and that calculated what you would need to pay. So no doubt there were fixed fees agreed, but it paid various fixed amounts.
So there was a sort of table of
Yes.
anticipated disbursements, and that was what was funded up front, and the solicitors were then allowed to deploy it as
Yes.
they thought, as became fit, and unfortunately it was deployed inappropriately.
Some of it, yes.
Some of it.
Your lordship might just see what went on that page. Item 5, GP notes, £80.
Mm-hmm.
You have to pay to get a copy of the GP notes. In the underlying liability trial, the findings of liability against the insured solicitors were primarily failure to challenge or investigate, go behind the initial instructions from the potential clients. The client would say, I started noticing I was deaf a year ago. It turned out it was several years before, and there were limitation problems. And the GP notes would be a very good way of testing the veracity of what you're being told on veracity by the potential client. But that would involve incurring a cost of £80, and it appears that this particular firm of solicitors didn't incur that cost, took them at their word, didn't challenge what the initial instructions were, and then that was held to be negligent. But you can quite see how, under the scheme of this contract, they could and perhaps should have incurred £80 of disbursements to see what the true position is, because people do forget, and the GP notes are going to record, you would have thought, any visits to the GP, any referrals to a consultant, any discussion about the possible causes of the deafness. And all that would weigh more heavily than the unaided memory of the potential client. And that they relied upon the unaided memory of the potential client. So that's how they could and perhaps should have incurred disbursements, but I think there's no indication that they were incurred in large part before, or any part before, the funds were drawn down. Could I go on back to page 142 of the core volume, and electronic bundle page 146, clause 2.1, IFSL shall offer credit facilities to clients selected by the firm in its discretion up to the aggregate sum set out in Schedule 3, without any obligation IFSL to make advances totaling such sum at all. So this is not a guarantee. And Schedule 3 is at page 157 of the EB and page 152A of the paper bundle. And it is worth looking at, because the agreement is dated the 7th of June, and at that date there was already outstanding to clients of Barrington £686,000 odd of loans. And then it envisages another 6 months funding up to 20 personal injury cases per month. So that's virtually one a working day. And then the new limit, which is not binding, is 1.1 million. And just to put that in perspective, the judgment sum of the bad loans, which were found to be the result of breach of duty or breach of warranty by the solicitors, was £581,000 odd. So the total advance to Barrington's, the insured solicitors' clients, was a considerable sum. And what was envisaged on a non-binding way was a fairly high flow of cases. So that's the non-binding facility. If I can go back to the contract itself at page 142, electronic bundle page 146, payment by IFSL, as soon as reasonably practicable following execution of a credit agreement by IFSL, IFSL will pay the cash price of the disbursements as follows. 1, to the relevant third-party suppliers as directed by the firm. 2, as the remaining cash price of the disbursements to the firm's client account as notified by the firm to IFSL in writing. So this loan is going to go either straight to pay disbursements that have been incurred at the direction of the firm or into its client account. And I will take your lordships to the consumer credit agreements and see how that's mirrored in those. This isn't just a loan to do what you want with to the clients, it is very tied down.
How's the fee payable to Impact calculated? That's 2.2. There's an administration fee.
That's defined, my lord.
I was surprised you passed over that. Were you going to come back to it?
It's an administration fee. Well, it's an argument we did try in the Court of Appeal without any conspicuous success. We got tied down in the VAT element. It appears to be in return for sorting out the Consumer Credit Act agreement, and it's not to be passed on to the client. But there is a fee payable, yes.
What's the fee paid for?
Well, back at page 140 of the paper bundle, or 144 electronic, a fee in respect of, is defined, a fee in respect of each credit agreement in the sum as notified by IFS to the firm from time to time, and payable by the firm together with VAT, if applicable, by way of remuneration for the services of ISFL.
Which can say it's by way of remuneration for the services of IFSL, full stop.
Yes.
So on the face of it, you say if you're paying a fee with VAT, if applicable, but if it's for remuneration for services, then it must be because there's been a supply of services.
Well, on the face of it, it would appear that there is a charge for the provision of services.
Well, services to someone.
Yes.
No, but the services have got to be rendered to the person, haven't they? I suppose it could be third-party consideration.
That's what Air Tours was all about.
Yes.
So payment for services to someone else.
Yes,
Yes.
but I don't know if we can get much from the VAT legislation or cases, because they quite clearly say they're not just looking at the contract, they're looking at economic realities. But the fact is the solicitor was paying a fee which was not recoverable from the client for the services of IFSL.
That may be important for Consumer Credit Act purposes as well, because hidden fees and charges.
But you say you ran that argument before the Court of Appeal.
It comes down to what is the service, or is it just in fact another way of making money for Impact? In other words, they get an extra kickback. In the world of these,
I don't understand that. I mean, it says by way of remuneration for the services of IFSL. Yeah. It's a recognition, this clause, isn't it, that IFSL is supplying services. Well, it's argued that it's only supplying them to the clients, but it's a bit curious that Barrington's cough up, and it's a bit curious that IFSL commit themselves to Barrington's to offer credit facilities to the clients selected by Barrington's, and commit themselves to Barrington's to pay disbursements at Barrington's direction and so on, which is a benefit to Barrington's because Barrington's are personally liable, and so on.
Well, indeed, our submission is that these agreements impose a number of onerous obligations on the solicitor. One is the payment of this administration fee, which from memory is not a very large fee. And others are the clauses 7.2 and clause 12 or 13, where they undertake potentially quite significant contingent liabilities. And they're doing that in return for something. And that's the point I think I will develop in due course.
Right.
And this is
Well, this obviously is of huge benefit to their practice in a general sense. They wouldn't have entered into it unless they were going to get clients out of it effectively, business out of it.
Well, it's clearly not irrelevant that the contract itself involves the payment of a fee for services.
Yeah.
It doesn't say to whom they're being provided, but it's payable by the solicitor without recourse to the client. And that is payable. And then
It's a bit like a facility. I mean, this is slightly different analogy. It's a bit like some sort of block facility or open cover given by an insurer to a broker. It actually only is going to insure the broker's clients, but is a huge benefit to the broker because he's got this facility in his pocket.
In fact, well, that was one of the analogies we put before the Court of Appeal as the way this agreement works, because a cover holder, a broker with the ability to bind, only actually has to act with reasonable skill and care, an implied term or express term of his appointment, when he does the insurance. In the same way, a lot of these obligations only are going to bite when a loan is made.
Of course. Yeah.
And it's a framework under which individual loans are then governed, or a cover holder agreement under which individual risks are written. And we say that's how it works. So clause 3, the payment clause, obviously only works when there's a loan made. Clause 4 has some undertakings as to how the money is going to be used. I was going to go... there are various undertakings to the parties which are relied upon my learned friend, who says this is all about each party having a requirement, the other will comply with their relevant regulatory regime, and I'll come back to that. But undertaking at 5 by IFSL, it will introduce and procure that all the introductions are made lawfully in accordance with the Introduction and Referral Code, an important consideration. Undertakings by the parties, each party undertakes represents the other that it will comply with all applicable laws, regulations and codes of practice from time to time in force. And that was relied upon as another way of getting an award of damages, but the principal one is clause. That's a mutual obligation. Clause 7 is the repayment undertaking by the firm. And the first is to repay out of the damages, 7.1. And 7.2...
Well, now that was the clause which was pleaded but not pursued to
Yes.
judgment.
And the advantage of this clause is that you get interest at the contractual rate from the solicitor. In other words, what the client's liable to pay, which I'm going to show your lordship is 16.9%, whereas the damages route, clause 12 or 13, you only get the cost of borrowing, which is 9%. So this is actually worth more money. This is your preferred route for getting money if the solicitor is solvent. Because you get and you get default interest as well, which is even higher than 16.9%.
So that was, I think we get it in the bundle at page 193 in the manuscript, clause 18 of the amended particulars agreement, in accordance with the terms of the agreement, specifically clauses 7, various others, the defendant is liable to pay the following sums which have been demanded.
Yes.
But then that was then followed by the claims at 23A for breach of clause 6 and breach of clause 13,
Yes.
which were what founded the judgment in respect to which the indemnity is sought.
Yes. So what happened was that at trial, as I understand it, and we learned it from Mr. Chapman, I think, was that did the trial, they didn't pursue the claim in paragraphs 15, 16 and 17, to which there was no obvious defence and was worth more money. They went down the more difficult route of proving negligence and loss and damage, which got them less money. So we would say that the primary, clause 7.2 is designed to provide security for the loans from the solicitors, as I will submit is clause 12 in this version of the agreement. So 7.2 is quite clearly a guarantee to repay the loans. Clause 12 is also there, and that might be relevant if there were a problem. This is the braces. If clause 7.2 is the belt, clause 12 in this contract is the braces, because if there's a problem with the enforceability of the CCA loans, which is the responsibility, which is caused by something that impact or it's its drafters of the CTA agreements are responsible for, so that they aren't enforceable against the primary debtors, that might afford a defence under clause 7.2, and that was actually run by one firm of solicitors, and there's a case about it, and they didn't succeed. But if 7.2 is a problem, you've got your fallback position of clause 12, and that is that they represent and warrant that the service provided by the firm to the customer shall be provided to the customer in accordance with their agreement with the customer, and that would include implied terms, but and then
Now, the judgment talks about clause 13, but
Yes.
that's what we are now looking at under clause 12.
and the reason I'm in this version is because we had the figures of the amount we're talking about
Yeah.
on this one. We don't have them in the other contract, so it's exactly the same terms, I think.
This is sort of what my lord called before the hearing a collateral contract, or a repetition of the primary obligation.
Well, without jumping too far ahead, and we're moving quite briskly, my submission will be that there's a big difference between a contract of retainer with a client, where the client gets the advice and is the client, and a warranty in a commercial agreement that you will comply with another contract.
Well, that goes back to your Swain point
Yes.
about what compulsory insurance is there to protect.
Well, also it goes to how you categorise this contract.
It also, I suppose, in theory, you would say, could lead to different measures of damage.
Oh, yes.
Yes.
Absolutely, because, for
Can you
example,
develop that?
the only interest that the respondent has is repayment of its loan,
Yeah.
plus the cost of borrowing, which is 9% to it. And it has no further claim. Suppose the solicitors fail to issue the claim form in time. The client has a claim for the entire loss of the claim, and somehow that causes the AT insurance not to respond. I don't know how it would do, but there was a problem with the AT insurance. All that the respondent can recover is its loan plus interest. The client has the whole claim. But on the particular liabilities we have here, the fault of the insurance solicitors appears to have been to taking at face value what they were told initially by their clients. Now, the client who sued the solicitors on that basis might face at least the defence of contributory negligence, because his case would be, you should have not believed what I said to start with and gone behind it and pressed me harder, and I'd have remembered that actually I'd been to the doctor 10 years earlier.
Right.
And also the measure of damages would be different, because the client would say, I am saddled with a loan at 16.9% now plus default interest, which I can't pay. So I've got to pay my entire liability, whereas the liability of the solicitors to impact is the lost advance plus the cost of borrowing, which is a lesser sum. So the measure of damages is different, and they have completely different interests in what's going on.
Yes, and the client's claim would not in all circumstances include a claim in respect of his liability for disbursements.
No.
Let us say the negligence occurred late in the litigation, and the client's claim would be the loss of the chance of success, which he would have used to fund
You say
the disbursements he incurred.
You say when construing the exceptions, you're not concerned with the content of the claim, you're concerned with the characterisation of the claim.
Yeah. What clause 12 is about, the clause 12.1, is forming a further form of security for the loan. Because it backs up clause 7.2. It's the braces when you've got the belt in 7.2, we say. It's not some altruistic interest in protecting the client's interests and say, we don't worry, we'll make sure that the solicitors act according to their obligations. The obligations are owed to the clients, and it's the clients who have the claims. And sometimes there's a sense that the respondent seeks to say, we are claiming almost in the shoes of the clients. We are almost standing in their shoes. We have the same rights, the same obligations. They don't. They have a warranty that the duties of the clients will be performed, but their interest and the contract under which it arises is a very different contract. It's not a contract of retainer. The client enters a contract for the provision of legal services. This is not a contract for the provision of legal services, and there is no provision of legal services to impact under clause 12. They don't get the advice. The advice that should be given, you haven't got a good claim, is to be given to the client, or you've got a good claim.
It's the retainer on the one hand and the collateral warranty on the other.
Yes. And as I say, the advice is not given to Impact. It's given to the client. And when one looks back at the little 2 of the exclusion, the point I've made is when we looked at it, it's about what is the nature of the contract, not the nature of the obligation in that contract, not the term of the contract which gives rise to the liability. It is the contract with the vision of a service to the solicitor in the course of private legal practice. So it's the contract that matters, not the term which is breached. And this clause 12 does not turn this into a contract under which legal services are provided to Impact.
Just taking my Lord's example, can we just think through the loss of prospects claim? If at some stage after disbursements are incurred, there's a loss of, there's negligence by Barringtons, which causes the claim to fail or be struck out. Wouldn't the claim? I mean, the Barringtons then have a claim. The client then has a claim against Barringtons for loss of the prospects of recovering whatever might have been recovered, including disbursements in the action. Wouldn't in fact Impact Funding's claim mirror that?
Well, it wouldn't mirror it. It would cover no more than its own loss, which would be the disbursements.
So it might be less.
That would be less. It would be different.
Well, we say it'd be different, but could it be more? I mean, it'd be more interesting from your point of view if it could be more. And at the moment, if you say it could be less, that's, so to speak, a protection.
Can I give an example where it would be less?
Yes.
The very liabilities we're concerned with. The client.
Yes, the client has lost the prospect of the whole recovery, including personal injuries, loss of
But
deficits.
if the assessment of the chance of success is at a low percentage, then it could be.
Yes.
But wouldn't Impact's damages also be on a percentage basis by reference to prospect of success?
Well, can I give an example which is based upon the liability we're dealing with here, and then as how it could be different? The liability of the solicitors for breach of the warranty is that they failed to investigate sufficiently the merits of the claims at the beginning. And in fact, when you read the judgment of His Honour Judge Waxman on that issue, he finds that what they were told sounded promising.
Right.
But they didn't go behind it, didn't probe.
Right.
Now, if the client sues and says, well, I told you that I only became deaf last year, but you should have checked and told me I was talking nonsense, I was deaf 10 years ago, either the client might have been shown to have known the true position.
Well, you make this point already. This is the contributory negligence point or defence
But it could
point.
produce
Yes.
the damages below.
Yes. No, I mean, I got that point. The Impact Solutions wouldn't be affected by the client's
And then,
negligence.
if we talk about loss of a chance to bring the claim
Yeah.
for some subsequent failure in the litigation,
Yes.
here's an example which I think would work. It's normally a condition of after-the-event insurance. Any offer which is made to settle the claim is communicated to the insurers. And it's a condition precedent to cover. It can be under the policy terms. Suppose solicitors fail to communicate an offer to insurers, then the claim goes ahead and fails at trial, but could have been settled, and they would have made it settle. So 80 insurers aren't liable to cover the cost, they're off risk. So the disbursements are unfunded, the client has no money. So the claim by Impact is for our the loss of the value to recover from the client, I mean the lost loan. We wouldn't have made the loan. We made the loss of the chance to recover the loan because you mucked up the insurance, we would have covered it. The client's claim is, you should have told me to take the offer, which was £50,000. It's a completely different sum.
Yeah.
Because their interests are different. The interest of Impact is solely its loan plus interest.
Yeah.
Interest of the client is in the claim and also potentially its liability under the Consumer Credit Act agreement. But that is an example, I think, which works. Having thought of it on my feet. But it would be where you, later on, the solicitor negligently causes damage both to the client and to Impact's ability to recoup in the intended way through the AT insurance. Now, just looking at these agreements, my learned friend Mr. Dutton, who is has been described as a doyen of the bar when it comes to professional conduct, and I think that's well deserved, may I say so. His case is that this agreement is all about each party's regulatory duties and the promise to comply with them. And that may be why he focuses upon it. In our submission, these agreements are commercial agreements between professional commercial, in the case of the solicitors' organisations, under which each party, quite properly, intends to make money. In the case of the respondent, it's by making loans, 16.9%. I've missed something out. I have to go back to it. Sorry, 16.9% interest when it's borrowing at 9%, and that's obviously nice for them. And then they also got under these agreements, apart from solicitors being encouraged to get their clients to take out these loans, they got guarantees of the loans through clause 7.2 and clause 12 potentially too, if that was the way it worked. But I should have shown your lordships the CCAs very quickly, and there, towards the back of the bundle, at page 296 to 7 is the one. There are several of them, but 296 to 7, EB page 301 to 2 is the first, which has both the front page and the back page in sequence, and it's the first page is a fairly standard Consumer Credit Act sheet of paper, as far as I'm aware.
So you've given us the
It's page 296, paper 301 EB. Right.
paper 301. I'm sorry, I'm using the paper. Yeah,
Paper 296. Sorry.
right, paper 296. Right. Yes.
It's a loan to
I see. Yes.
Mr. He's blank.
Yes.
And then over the page there were some clauses, terms and conditions. And they're in rather small print. Clause 1.2: the purpose of the loan is for payment of outlays incurred by you to the solicitors, the firm, professional services in relation to your claim for damages, the claim. Clause 2.1: the borrower irrevocably authorises the lender to pay the amount of the credit to the firm. Clause 2.6: if at any time prior to the date upon which the total amount payable is payable by the borrower, the firm is the subject of an intervention, which is a power given by the Law Society to intervene in the affairs of the law firms in certain circumstances, or the lender reasonably believes that the firm is not progressing the borrower's claim in a prudent and timely manner, the lender may, if it reasonably considers that it would assist the borrower, to appoint a replacement firm, direct the borrower to appoint such a replacement firm from the lender's panel of firms, in respect of the conduct of the firm, of the claim. And then later on, it's an event of default, clause 3.7, if the solicitors are disinstructed, and 3.8, it's an event of default if the borrower won't agree to instruct a replacement firm pursuant to clause 2.6. So what this is all doing is tying the client in to the money being in the solicitor's client account used for disbursements. And it's necessary to have that tied in so that Impact can comply with its obligation to pay the monies to solicitors. Pardon? I'm sorry, I'm also reading at 2.3. The borrower irrevocably authorises the lender to obtain from the firm all sums payable to the borrower under it or in connection with the claim or settlement of the claim, which shall be paid towards discharging any sums due under this agreement. And that's the mirror of an obligation in the DFMAs to repay the loans from the proceeds of the claim.
If you're right on the present point, it would be open, would it not, to Impact Funding Solutions to sue all the individual clients who would then in turn have precisely the same claims against Barrington's as Barrington's have been held to be liable in respect of to Impact Funding Solutions, and the clients would then be able to use the Third Party Rights Against Insurers Act to pursue your clients.
If they were liable for the same amounts.
Well, wouldn't they be? I mean, Impact Funding Solutions are not suggested to have been in any way mixed up with Barrington's shenanigans, And so impact funding solutions can say, we've got a lot of disbursements agreements with you. We've done exactly what they called for, namely funded 3,500. In fact, you're not only liable to repay that, you're liable to repay it with 16.9% interest. And what Barrington's did with it on your behalf is none of our concern. They may have misused it. They did misuse it. That's your complaint against Barrington's. You can sue Barrington's, and since they're bust, you can sue AIG.
Well, I agree that the borrowers are on the face of it liable under the loan agreements.
Yeah.
And they would, subject to any points they could take under the Consumer Credit Act, they would be liable to pay the full amount plus contractual interest of 16.9% plus default interest if they were in default. They would then potentially have a claim against Barrington. That would be a claim saying that you should have told me at the begining. That
Well, that's
what I
exactly
told
the
you,
claim which has been held to exist by His Honour Judge Waxman, hasn't
Well,
it?
no, my lord. This is the point about, with respect. They would be saying, I told you that I became deaf last year.
You mean then you get into the contributory negligence points? Yes,
It's not so straightforward. And also, my lord,
yes.
many is the case where a client of the system might say, well, I've incurred a liability because of your advice.
Yeah.
Doesn't mean the person whom the liability is incurred can sue the solicitor directly. The insurers directly, rather. Sorry, the client, what again? A client of the solicitor might say, you, the solicitor, negligently exposed me to a liability.
Right.
To a third party.
Yes.
The third
led me
party
up the garden
will not
path.
necessarily sue the solicitor directly. It has to sue the client. It's the liabilities of the client to the solicitor. And the liability, in other words, that's a situation where the third party sues the client who says, I am facing a liability which you've exposed me to, and I sue the solicitor. The third party can't shortcut that and sue the solicitor.
Who's the third party? Yeah. In your
Well, anyone who it's a wide application. Any situation in which a solicitor's client, relying on the advice of the solicitor, ends up being liable to a third party, and that could be you tell me that I can do this without breaking my contract, and it is a breach of contract and held to be such.
Yes.
I rely on your advice. I then say I wouldn't have done that had you told me it would be a breach of contract and it would cost me all this money. And so therefore I recover that against you. But the person who has the claim against the client can't just sue the solicitor straight away, directly.
No, right. I don't think I was suggesting
No.
the contrary.
Well, that in a way that here the client borrowers are liable to impact. Impact then, they then potentially have a claim.
Yeah, I mean, your best point is that the client's claim against Barrington's is by no means assured. There could be all sorts of complications.
And even so, it would not follow that the people to whom the clients are liable can sue the solicitors directly. That's the point. It would
Well, I
be.
don't understand why they come in. We're talking about what the clients could do.
I know.
We're talking about clients that's exactly, who've been liable for disbursements to impact.
I'm going down the line a bit, well, perhaps I'm getting the wrong point.
I think we've probably got the right point.
I hope so.
I mean, surely, the simple point is that the clients may have a claim
Yes.
against the insurer, against you.
But you can't just say, well, let's just shortcut it.
Yeah.
There's no shortcut.
Well, no, I wasn't suggesting a shortcut. I was simply suggesting that I was trying to test the underlying merits, perhaps, of your position. But I do see that you have an argument, Mr. Dutton can deal with it, to the effect that there isn't necessarily a different route to the result which you're now trying to avoid. There might be quite a different result from the one which Mr. Dutton is now contending for. He might get endless judgments against the clients which would never be satisfied, and the clients might seek to recover their liability from Barrington's, but be unable to do so because they failed to inform Barrington's properly in the first place.
Yes.
Yeah. Right, carry on.
And in terms of the insurance cover, just to make it more interesting, each claim by the client would be a separate claim and attract a deductible or excess. There would be a provision in the policy for a number of excesses, whereas only one deductible for the claim by impact. So the coverage position would be different as well, potentially.
What is the deductible?
Well, normally solicitors pay, there's a small amount of liability which a solicitor bears himself.
Yes, I know, but what is it in financial terms?
It's at page 209 of the bundle, divider 11. That's the paper reference, page 214 of the electronic bundle. The retention is £20,000, subject to an overall annual aggregate of £80,000.
Sorry,
60,000, I'm sorry.
209, yes, I see.
Yes, so here there would be a deductible of £60,000, because that's the maximum, £20,000 each and every claim, sorry. But were each client to make a claim, then if they all made it in the same year, there would be a total of £60,000 deductibles.
Well, if it's retention, it's called a retention, which is a pretty old phrase, but
Yes, but
it's a retention of £20,000 each and every claim. If that really means deductible, the clients could never have a claim in the present case because they only each drew down £3,500.
They would have to get that off. They'd be relying upon Barrington to pay that amount of money because there's no insurance cover. And then...
I see.
Actually, I have a feeling that...
Well, each and every... It depends what that...
Yes.
It would depend whether, as between Barrington's and AIG, this was one claim or there was a separate claim for
I need to be
each
careful.
client. It's clearly one claim by impact.
I need to be careful. It's possible that when one looks further into this, that the insurers pay to start with and recoup the retention from the solicitors.
I was going to say retention, I don't understand.
I may have taken a bad point there.
Yeah.
Although in theory it does impact whether there's a solvent insured, whereas an insolvent one, in order to protect.
I don't recall. I mean, I don't recall deductibles in professional negligence policies, but I may be wrong of this sort. Yeah. So.
Well, that may be a bad point. I was going to come now to why the judge at first instance was right and we are right, and get to the meat of the argument. Retention.
That does appear to be should only pay the amount of any loss which is in excess of the retention.
Yeah, which is why there have been so many battles down the years about numbers of claims.
Yes.
Yeah.
Which is often turned on the question of deductible, and in some circumstances in the interests of insurers to argue that it's all one claim, and in other, because there may also be a total figure. In other cases, it may be in their interest to argue that there are a lot of different claims.
I understand my clients have an application permission to appeal to your Lordship's Court about aggregation and solicitor's minimum terms pending. So,
right.
But this is quite a big point actually, because it does. If this point is a good point, it means that a claim by impact is undoubtedly a single claim. Undoubtedly, or is it a series of claims?
There's an argument about that because in theory it may well not be actually.
Yes, you may be right. It may be it's as many claims as there are clients. In which case, why is there a claim at all if there's a retention of 20,000 each claim?
Well, it's subject to an annual limit of £60,000. So after that,
yes, I see.
It drops away. So it's
I see. So the 60,000 would be deducted.
exhausted in any event, and then it would be hit the limit of cover.
Yeah.
So I'm afraid I think that the point about retention is a red herring, and I would rewind back 10 minutes and ignore that bit if that's all right, because it doesn't actually probably advance matters, and it may complicate them unnecessarily. I was going to say move on to why the judge and we are right, and the judge at first instance in our submission adopted entirely the correct approach and reached the right conclusions, and it will be a matter to contrast his approach with that of the Court of Appeal and see how we're taking a different and, you say, incorrect approach leads you into error. And the judge had the advantage of having tried the underlying liability of the solicitor to impact. So he had actually spent some time being taken through all the documents which aren't before us and seeing how the scheme worked and seeing what had gone wrong and seeing it in some detail. And his judgment, which I'm not going to take the lordship to, is for reference in the core volume behind tab 6, pages 112 to 24, electronic bundle, page 116 to 28. And he sets out early on how the scheme works in some detail and talks about documents he's been taken to and shown and examples. He then tries a number of example cases and finds liability. So he had the advantage of having done that exercise and having therefore a greater understanding, we would submit, of the underlying liability than an appellate court would have. Indeed, that I have, because I wasn't there either. But I was going, in the interest of time, to take your lordships to his judgment as between the present parties, which is at divider 7, 125, electronic bundle, page 129. And as my learned friend, Mr. Dutton, has pointed out, I took a number of points without success, which we didn't appeal. But the relevant part of the judgment is at page 137, paper 141, electronic, paragraph 47 to 59. And we say this is exactly the approach which should be adopted and which the Court of Appeal failed to adopt. AIG contends that even if I has found that liability...
We don't have to read it, we have read it. Which are the...
It's paragraph 47...
Yes, which are the particular points you wish us to look at briefly again?
Paragraph 54 is the kernel of it.
54 is the kernel of it. Having analysed carefully the wording used and the agreements, looked at realistically and commercially, I consider in these circumstances, Impact was providing a service to Barrington. The service was disbursement funding for a particular claim. The funding would not be provided through Barrington unless Barrington requested it via Veracity, that's the system claims identification. Since the loans were not made to Barrington in any beneficial sense, it would be wrong to characterise the service as financial services. They do not have to be. Impact was making available to Barrington a valuable facility at Barrington's option, namely claims whose disbursement element, including the all-important ATE insurance...
Or shall we read it to ourselves?
Yes.
Right. Well, you say that's right.
And he's on to consider... Paragraph 55 is also relevant. He did consider the whole scheme of the agreements.
Well, basically, he says they're paying for something, yes.
And then at paragraph 57, he refers to the judgment was on Judge Hegarty in the Sutherland case, which is in the bundle of authorities, where he sets out there, and I can save time, it's in quite small print, but for slightly different, but broadly similar, slightly differently expressed, but broadly similar reasons, Judge Hegarty reached the same conclusion in an earlier case.
Yeah.
And we say what he's done here is he looked at the wording, construed it, looked at the contract, and then reached a conclusion that realistically and commercially there was a service being provided.
And moving to the Court of Appeal, you say they really failed to focus on this.
Yes, I'm going to come to them. I was just going to bolster that by making a couple of points why we say he was right to make that conclusion, if I may. First of all, we say that the DFMA worked on a number of levels. The first was Clause 2.1, there's an agreement in principle but not binding to have a facility of 1.1 million. That isn't itself an enforceable obligation. Then the second tier, there are a number of obligations to maintain insurance, to comply with regulations, which apply on the face of it, whether a loan is made or not. But there's no actual obligation either by Impact to make a loan or for Barrington to recommend to a client to take a loan. If Barrington discovered that someone was providing legal loans at 12% interest, they would indeed be bound not to recommend Impact, but somebody else. But those obligations to maintain insurance have no content until loans are made, because what will be your damages for breach of that obligation. There's no exposure. And the key operative provisions, we say, come into effect, including the clause 7.2 guarantee and the clause 12 or 13 obligation to carry out the underlying claims with reasonable skill and care. They only are engaged each and every time a loan is made. You can't, until the loan is made, the guarantee obligation has no content. Until a claim is being pursued with the benefit of a loan, the obligation to pursue that claim, the warranty rather, that case will be pursued with reasonable skill and care, has no content. And so it is at the moment that each loan is made that the key obligations are triggered, and also, we say, as the judge found, that a service is provided to the insured Barrington, because they are then put in funds by their client borrowing money to fund the disbursements. And as the Lordships have seen from the schedule to the first DFMA, to a considerable extent overall. And a solicitor is bound to pay disbursements, this is agreed otherwise, on behalf of his client, and then seek to recoup them. And we've set out in our case an extract from Cordery which makes that good. And as I showed your Lordships when going through the definitions, the contracts, DFMAs themselves, recognise that solicitors incur disbursements and are liable for them on behalf of their clients, with the right to recoup from their clients. So we say that a service was provided, and if it's a contract that provided a service to Barrington, the insured solicitors, then it falls within the sub-clause 2 of the exclusion, which isn't surprising at all, because the respondent was not Barrington's client. It wasn't the beneficiary of legal services, although Barrington was potentially liable for breach of the warranty. The only interest the respondent had was in its loan and interest on the cost of borrowing to fund the loan. It wasn't the client or some sort of quasi-client like...
Well, I think we've got all these points.
Yes, I'm sorry.
Yes.
So where did the Court of Appeal go wrong? And this is about to look at their judgment, which is Divider 2 of the core volume, page 97, and the electronic bundle, page 100. And the ratio is commendably short, put it that way, but in our submission, it's gone wrong. And it's paragraphs 19 to 22, which are the key passages. And at paragraph 9, all the judgment of law says long more than the other members of the court agreed. In order to assess these rival arguments, one has to stand back from the detail and ask oneself, this is paragraph 19, what is the essential purpose of the exclusion clause 6.6? And this is the beginning of going wrong, because instead of saying, what does the clause say, it's saying, stand back, what are these sort of clauses about? And rather than look at what they say. And that risks failing to appreciate what the parties have intended, because you're taking a view standing back and just saying, oh, it's trade debts and liabilities, and not looking at the wording. And he then identifies...
but he's really taking what I described as the second point, isn't he? He's saying that whatever it is, this clause was intended to, whatever the nature of the contract or arrangement was, this clause is only intended to exclude things which can be described as personal as opposed to professional liabilities. And here we're talking about professional liabilities, albeit incorporated into a service contract.
Well, how one knows what the clause is, this goes back to the basic principles of construing contracts. You look at the words used. How do you know what the parties intended? You either start by saying, I know what they intended without, because this is what these clauses always intend, or you can read what they've actually said. And to know what these parties have intended, you should read their contract. And he's not done that.
Well, the position is fairly straightforward, isn't it? In order to effect, and both propositions may be true, it may be the object of this to remove, quote, personal, unquote, liabilities of the solicitor, costs of running their practice effectively. but sometimes in order to catch a category which is difficult to define, you need to have a larger category which is easier to define. And so what they've done is produce a clause which operates entirely by reference to the character of the agreement and not the circumstances in which the liability under it came into existence.
Yeah.
And that is one of our key submissions. What I'm grateful to hear it coming back.
To which a contrary submission is the one we've been over, namely, if it's precisely the same liabilities they would have had to the client, then a bit odd that it's not covered. But you say, anyway, it's not precisely the same liability.
The reason the nature of the contract is so important is because the protection is of clients and quasi-clients, people like intended beneficiaries, people to whom the solicitor assumes responsibility in Headley-Burn sense.
Not service providers.
Not commercial lenders who are part of the funding process.
Fine.
You said there are separate interests, and the policy protects the interests of A, it doesn't protect the interests of B.
Legally, it's not the same liability. What is the same is the facts that give rise to a different liability.
Well, exactly right. The facts which give rise to the liability
They're
are
the
the
same.
same.
But the
the term is
contracts are different.
Yes, the contracts are different and the term is different. One's a warranty and one's a promise. One's a warranty, I'll comply with another contract.
Yeah.
And it's given in a different context.
So what else is there in the Court of Appeal's reasoning which you want to address?
Well, paragraph 21, my Lord, is a paragraph which we in our submission is rather hard to understand. In paragraph 20 is really identifying a question. Then it seems to me that obligations arising out of such loans...
No, it's paragraph 21 surely is the point we've discussed at some length, namely the mirror image point. That's the argument against you.
Well, can I go through it, my Lord, and just see how it's put? Because it seems to me that obligations arising from such loans made to have disbursements in intended litigation are essentially part and parcel of the obligations assumed by a solicitor in respect of his professional duties to his client. Well, my Lord, the obligation, that would appear to cover 7.2 guarantee, or the promise to provide accounts, which is one of the promises.
Yes, I see.
The obligations under the DFMA are very different. And what Lord Justice Longmore, with respect, appears to do here is to start losing sight of the fact that there was a warranty of one of the obligations under the DFMA, but there are plenty of other obligations. And read literally, it means that the solicitor was obliged to enter the DFMA and give these guarantees in order to discharge his duty to his client. And that simply can't be right. The solicitor is not obliged to guarantee a loan the client needs in order to run the litigation. But read literally, it says the obligations arising out of such loans, the obligation to guarantee it, made to cover disbursements, are essentially part and parcel of the obligations assumed by a solicitor in respect of his professional duties.
Well, they go on. The clause does go on. The paragraph does go on to deal with the professional, the negligence liability.
They're inherently part of professional practice and are assumed as an essential part of his duties to advise the client.
Yeah.
It is an essential part of his duty to his client under the contract of retainer to do so, but this is not. He is warranted to secure a loan that he will do so to these people, but they're not the clients. He doesn't know a professional duty to.
Well, I think you're repeating yourself.
I put my line.
Yes, I think we've got this point.
What
What more do we need to look
Well,
at?
it does get more puzzling because disbursement should not be incurred litigation which is unlikely to succeed. That's absolutely right in terms of a client. A solicitor who negligently advises a client that a claim is likely to succeed and causes a client to incur disbursements which have not been incurred will be liable to the client for disbursements easily incurred. Right. It should make no difference to the point of view of a professional indemnity insurer disbursement has been incurred before such advice is given or without. I agree in terms of liabilities of the client. But what Lord Justice Longmore, with respect, has lost sight of is that this is a liability not to the client, but to a lender.
Yeah.
Yeah.
This is the same point.
It is the same point, but it's where it's gone wrong. And it's because it's the great thrust of the Friends case is that this is the same obligation.
Yes. And
we say, well, first of all, the exclusion clause is concerned with the nature of the contract, not the relevant term that's breached.
Well, I think we are going over the same point over and over again. This doesn't help to continue to hammer it.
Well, I think I'm going to finish well within time, and I'm on the home, probably very much on the home straight and not very near the finishing line post. So I'm just going to look through my notes and see if there's anything I've missed out, having made the same point many times. But we say the confusion probably came from the fact that my learned friend keeps trying to say it's the same obligation. It's not. And he keeps trying to say, well, we're effectively in the same position as the client, and they're not. It is a warranty, the duty we performed, not that. And he makes the point many times, but in his case, paragraphs 21, 30, 4 and 34.
Perhaps not the only one who's making a point several times.
No. But that
I think there's a finishing line in sight.
yes. I would just mention that if it were to stand unchanged, paragraph 21 does cause problems, but this court will sort that out whatever happens.
Sorry, paragraph 21.
That does cause uncertainty, because it's quite hard to understand precisely what's being got at in it and how it applies. And this category of professional debts, which is somewhere between trade and personal, is quite a difficult one to understand, but we would invite your lordships to get rid of those difficulties by allowing this appeal. And that is the finish.
Thank you. Ms Dixon. Thank you very much. Yes, Mr Dunn.
My Lord, we make 3 submissions. The loss which Impact suffered as a result of the negligence and breach of fiduciary duty by Barrington to its clients fell within the scope of cover under clause 1.1 of the minimum terms and conditions.
Yes.
Second, that loss is not excluded by clause 6.6b of the minimum terms because the DFMA is not a contract for the provision of services. And third, what my Lord Mansell has been calling the second point, it is not a clause which excludes what we say is the professional liability of the solicitor to his client. On the second submission, there are various sub-issues. First, this I know my Lord doesn't want to hear too much on, and I'm very glad I won't say too much about it. 6.6b is an exclusion clause. The language at the start of clause 6 of the standard terms prohibits any exclusion which goes wider than the language of 6.6b. It therefore follows that it will be construed strictly. We say, thirdly, the exclusion in the policy and 6.6b permits an insurer providing insurance under the minimum terms to exclude liability where the proximate cause of the liability is a breach by the insured of the terms of any contract or arrangement for the supply or use by an insured of goods or services in the course of the insured firm's practice. That's the language. In the context of this case, that means that in order for the exclusion to apply, the court would have to construe the DFMA as a contract for the supply or use by Barrington of goods or services. And fourthly, we say the DFMA does not fall within the exclusion at all, the categorization in question. And fifthly, it does not operate to exclude the professional liability obligation. My Lord, can I start with falling within the scope of cover? And I want to deal with this is or isn't the same loss suffered by my client Impact as the lay client. The first point to make in relation to that is that the loss suffered by Impact falls full square within the insurance provision 1.1. It's at core page 231, electronic page 236. My Lord, in discussion, perhaps understandably, the court is looking to see how much overlap there is or isn't between the client's claim, potential claim, and my client's claim. But my Lord, my primary submission is this. Our loss, whether it's the client loss or not, falls full square within the civil liability provisions under the scope of cover.
Yes.
And the second point I make is, on the facts of these cases, it's clear that the loss is the same to all intents and purposes, so that even if the court were looking at the differences between the two, it would take us nowhere on the particular 176 cases which gave rise to this problem.
You're coming back to that, are you?
I am.
Yeah.
So the obligation under 1.1 must indemnify each insured against civil liability to the extent that it arises from private legal practice in connection with the insured firm's practice, and then the provisos don't apply. We needn't worry about that. And if we turn through to the definition of private legal practice, page 243, EB 248, private legal practice means the provision of services in private practice as a solicitor or registered lawyer, including, without limitation, a good degree of the provision of services. Now here, the loss, whether the loss suffered by impact, indeed the losses suffered by the clients, arise out of a civil liability from private legal practice in connection with that practice. So we are...
So liability to whom?
Well, my lord, as it so happens, the liability to me.
I mean, we're concerned
To my
that we're
clients.
not... Well, that, yes, because that is the relevant liability, isn't it? We're concerned with whether your client's claim for the loss which they have suffered, being a claim for breach of contract, falls within the ambit of 66B.
Yes.
We're not concerned, are we, with whether a claim by somebody else with a different interest, who suffered the same loss, but whose claim was put on a different legal basis, would or would not have cover under the policy.
2 points there, my lord. I accept my lord's basic proposition, but my clients are claiming a loss which has arisen in respect to a civil liability arising from private legal practice.
If you just look at 1.1, you say you're within its terms.
We are within its terms. That became common. That was disputed, although it became common ground by the time we got to the Court
And
of
that's
Appeal.
not contested now.
And not contested. And therefore I say we fall full square within it. As to my lord's second point, the client, it's a slight danger, I'm going to go and make this submission several times, for which forgive me, but the client's recovery in this case is for claims which should not have been taken on conditional fee agreements with after-the-event insurance, where the solicitor should, before making the client, enter into the CFA or the CCA loan agreement or the after-the-event insurance, have investigated the merits so as not to commit the client to the liability which is the loan from impact. To all intents and purposes, my lord, there is going to be no realistic difference between the two claims. The client's claim...
impact is not subrogated to the position of the claimant.
We're not.
The claimant's claim arises under a contract of retainer.
Yes.
Impact's claim arises under the DFMA.
Correct.
And the question is whether the DFMA is caught by 66B. We don't get the answer to that by looking at some other claim by another person on a different legal footing.
Correct, my lord. I'm meeting here my point here is, first, the starting point. We fall full square within 1.1, I submit. And second, I'm leading on to the second submission, which is the two claims are, as a matter of fact, going to be, if not identical, extremely similar. That's to meet my learned friend's point, that the lay client's claim, it arises under a contract of retainer. The lay client's claim will be a claim in breach of contract and in tort in parallel.
It's a different contract.
Yes, it's the CFA under which the lay client, but the loss which the lay client is suffering is going to be to all intents and purposes, the same losses as the judge awarded. And I submit that I am now into the second submission, constitute my Lord's question. I submit that also follows from the breaches which are contained in the DFMA, clauses 6 and 12 or 13. Those require the solicitors to discharge their professional obligations to their lay clients. Mm-hmm. If they're in breach of that obligation, my client, the lender, is not going to recover more in terms of loss than could arise for breach of those duties, and those are the duties owed to the lay clients. So although my client's recovery is under the DFMA, it happens, and I will take my Lord to Long Judge Waxman's judgment, where one sees that effectively the client is being taken into the loan liability, his disbursement liabilities, the after-event insurance liability, and is having his own loan monies improperly deducted for the solicitor to pay his acquisition costs, quite improperly, in breach of trust and fiduciary obligations, all of which are losses which the client suffers and which, effectively, my client is able to recover either in whole or in part for the loan provided.
Presumably there are situations in which, at least in theory, the insurance against civil liability, to the extent that it arises from private legal practice in connection with the insured firm's practice, the civil liability in question could be tort liability to some third party other than the client.
Well, my Lord,
and that would actually give rise to a measure of liability which depended on the third party and had nothing to do with any claim the client could make.
Absolutely.
Can you give me some examples?
The Headley, Byrne and Heller.
Exactly.
The Headley, Byrne and Heller example is a very good one, where a solicitor may, in circumstances where he doesn't have a client relationship, nevertheless owe a duty in tort. And that
that's a sort of quasi. That's all sort of quasi-client situation.
Well, my Lord,
but aren't there situations where solicitors? I know we don't encourage this because you tend to think of the solicitor's duty as confined to the client. But aren't there situations where a solicitor may incur in practice
beneficiaries?
Yes.
Right.
Sort of
breach of the duties under the accounts rules, where there may be third parties. Breach of duties in terms of the giving of undertakings to third parties or other solicitors.
Undertakings are conveyancing transactions seem the most obvious example.
Yes, conveyancing transactions, they occur. And the insurance provisions are plainly cast wide enough so as to ensure that where a solicitor in the course of his private practice incurs liabilities for his professional obligations, they will be covered under the policy. And I submit, do now get into the next submission, that impact is, that there's no policy reason for thinking that because impact is requiring these obligations to be given under a different contract from the client, that somehow should lead to the exclusion applying.
Can I just ask you on that? I mean, if the DFMA is not a contract of services, then the whole thing disappears.
It does.
If it's a contract of services, so that prima facie it is excluded by 66B, is it your submission that the exclusion in 66B is itself subject to an exclusion, that it excludes a case where the loss claimed is the same as the loss which has been suffered by somebody who could have made a claim against the insured, in respect of which the insured would have had cover?
I submit that
And is that the legal proposition?
The legal proposition is that the exclusion must not be read so as to exclude the professional liability for a loss, in respect of a loss, which arises from the breach of the duty.
But hang on. Professional liability doesn't exist in the air. Professional liability is to somebody.
Yes.
And that's why I think you're put in conceptual terms, I think your submission is that the exception, if it prima facie applies, is to be cut down by an exception to the exception where the loss arises from a breach of a professional duty to another person who would have had a claim which would have given rise to liability under the policy.
My Lord, yes, I wouldn't have put it in quite those terms because...
Is that not the
But
substance?
I reach the same point that my Lord does.
Yeah.
The way I reach it is you read an exclusion clause as not seeking to cut down effectively recovery for a loss for the discharge of the professional obligations to the client in circumstances where the exclusion is aimed at trade debts and not at excluding the liability to the lay client.
Can you put it the other way around and say that the exclusion is clearly aimed at excluding liability which would be specific to or special to a contract for the supply of goods or services? In other words, something that relates to the nature of such a contract rather than to professional liability.
But if one does it that way, you've still got to identify to whom, because liability isn't like a hanging chad. It's to somebody. If you're talking about a professional liability, one's always got to identify, has one not, to whom.
My Lord, the answer to my Lord's question is no for the purposes of the insurance policy. Can I explain why? Under the insurance policy, as our earlier discussion indicated, a solicitor may be liable to people who are not his clients. In other words, let me take an example. A solicitor, the insurance could not exclude the solicitor's liability, for example, under the solicitor's accounts rules, owed to any number of people. It could be somebody in a conveyancing transaction who's not his client. It could be a beneficiary under a will and so on. Nor, for example, to my clients who are lenders.
And I entirely agree that the liability may be to a person, somebody other than his client. But I don't think that removes the point. You still have to identify the nature of the professional liability and, importantly, to whom it is owed, whether it's a liability to the client or a liability to somebody other else. And because it's once you've identified to whom the liability is owed as well as how it arises, that you can then see, can't you, whether that liability is or isn't within the policy.
Well, by definition, if we have a contract, liability under a contract for the supply of goods or services, the liability is going to be owed under a contract which is with someone other than the client.
Yes.
So that, so to speak, solves that.
Yes.
And so one's then looking at the nature of the liability.
One looks at the nature of the liability. That's why I started with clause 1.1. One looks at the nature of the liability. Can I just draw...
Yeah. I mean, at some point it'd be nice for you to be allowed to say how you actually put it within terms of the...
I will get there. I will get there, and I'm sure...
Debate going on here.
Can I just take another example? The loan monies were, as was said in the pleadings, quis close trust monies. They are monies provided to, under the terms of the CCA, to the client's solicitors, to be held in the client account for a specific purpose, namely the discharge of proper disbursements. So that what happened in this case, where the solicitors used approximately £600 or thereabouts of loan monies to pay referral fees, is a breach of one of the primary obligations that solicitors owe under the accounts rules, namely only to discharge the payments of monies in client account on behalf of the client. That obligation, I'm taking this by way of example, that obligation is an obligation owed to my clients pursuant to the terms of the DFMA and also to the lay client.
There wouldn't necessarily be a liability in these circumstances to the client, would there? Let us suppose that the solicitor advises the client that this is a hopeless case which he's going to lose. And the client then says, well, I don't believe you. Hope springs eternal, and I think the judge may think well of it. Now, there isn't a breach of duty in that situation to the client if the solicitor proceeds with the CFA and the rest of it at the client's request, notwithstanding that the solicitor may end up breaking obligations to all sorts of other people.
There may not be,
There may
my
not.
lord, and in that
Well,
situation...
that's good enough for my point.
Yeah.
Or would there be a breach in
There
this
wouldn't
contract?
be a breach of the undertaking 6.1
Oh, yes.
and 13.1, which
Because that's effectively a warranty.
that you're going to comply with your duties to the client.
Well, well, you have complied with your duties to the client in that case, but it's also a warranty that you have done certain things by way of ensuring that there's merit. And that's a separate duty, which doesn't necessarily coincide with the client, because the client may say, I don't care about the lack of merit.
My lord, the example, I accept, is correct, but here, as one sees from the liability judgment, the problem with these cases was that the solicitors did not investigate and advise the clients on the absence of merits, and then incurred the disbursement liabilities, such that
On
the
these
client...
particular facts, you can say there would have been a liability in the same amount under a different contract.
Yes.
But your problem is that you are dealing with a clause which operates entirely by reference to the kind of contract which has been broken on the face of it. And I'm not quite sure how you get this further limitation that the exclusion doesn't apply in cases where there would have been a corresponding liability to the client out of the language of the clause. I mean, do you say that this is an implication, in which case one's bound to ask what makes it necessary or reasonable? Or if it's not an implication, how do you get there as a matter of construction?
I get there because I say it cannot operate so as to... on the facts of this case, it cannot operate to exclude the liability owed to my clients to discharge the solicitor's obligation to his own client. It's because it's an exclusion clause, one can't read it to have such breadth. It can be read to exclude the liabilities that arise under a service agreement.
So you say they can't really have meant it?
Well, my lord,
Not literally, anyway.
I have the Court of Appeal effectively saying that at paragraphs 19 to 21.
Yes, well,
that's
that seems to be a
That's not a
slightly,
principle of
slightly problematical approach.
No, but it's quite. It has its attractions. Maybe
Yes,
that's not a principle of construction either.
common sense approach. Yeah.
I mean, one can
Well, my lord-
sometimes limit an apparently general provision by reference to its subject matter. You can say, well, all of these clauses are about a particular kind of subject.
Yes.
But we're not in that category.
Well, my lord, that is another submission I would wish to make. We are here looking at trade debts in a particular, of a particular kind. Let me just make the point.
I mean, your primary point is that we aren't within the scope of this clause at all. So, to some extent, we've taken
We're now
you
into the
ahead
secondary point.
To the secondary point, and maybe we ought to allow you to develop it.
Lest I lose the point that arises from the question, my lord, then I will develop it.
I don't suppose Lord Sumption will lose it.
No, I'm quite sure he won't. Can we have a brief look? I'm sorry, I will come back to it, but otherwise I won't be helping. The exclusion under the policy at call 217 EB 222 is, as I think Lord Hodge noted when looking at this, of trade debts arising out of...
No, it isn't, surely. To read it grammatically, you have to start on the previous page. Exclusions. This policy shall not cover loss in connection with any claim or any loss, colon. And then you have a series of headings. So trade debt is not part of the wording, it's just a heading. So you have to read on, or any loss arising out of.
Yeah. My lord, the point I was going to make is that frankly, if one looks across at the standard terms themselves, next tab at 6.6b, and it may be this point. the exclusions at 6.6b, one reads across from 6 to debts and trading liabilities. It may well be that the grammatical effect is the same, my lord. The purpose, in any event, is to exclude trading debts under the policy, not, I submit, professional liabilities.
Well, this really isn't a professional liability, is it? It's simply something that would be a professional liability if the same facts were in issue between the solicitors and their client.
Yeah.
Yes.
It's actually, I mean, the solicitors entered into this arrangement in order to promote their own practice. It has exactly the same commercial purpose as if they'd taken advertising pages in professional journals and so on. And part of the cost of doing that is that they had to incur certain liabilities, personal liabilities. Now, against that background, you can't really say, can you, that this is not a trade debt. It's part of the cost of running the practice. The fact that the same facts would give rise to a different claim by a different person against the solicitor is neither here nor there.
My lord, I do say it's not a trade debt. I don't accept the starting proposition of my lord's question for this reason. These arrangements are the post-legal aid arrangements, which this court knows only too well, came in after the Access to Justice Act. So what you have here are people in the Northwest who say they have suffered industrial deafness. They don't have access, as would formerly have been the case, through legal aid to their solicitor. What they have to do and what the solicitor must do, so far as they are concerned, is advise them before taking on the commitment that they have a claim which has merit, that there will be funding in the form of the loan, and that they have sufficient merit to justify incurring the after-event insurance liability. Now, those obligations which are within the DFMA are the obligations owed to the client in order to get the client to the starting block of being able to bring his claim for industrial deafness or not. And in this case, they should not have been brought to that position because the solicitor failed to give appropriate advice and therefore caused them to incur liabilities which they should not have been caused to incur. And it caused my clients to make the loans which should not have been drawn down. So, my lord, your lordship's question, it is undoubtedly of benefit, I've accepted that throughout, to the solicitors that this contract is in place. It enables them to have clients where they do not have to fund the disbursement liabilities themselves, but it is not the same as advertising. Can I just give you the reason for that? Advertising is not dissimilar to a referral fee. The referral fee is paying somebody who has gone out to the world to find clients for you. And that is not a proper head of payment.
Contrary to the Law Society's rules.
It's an unlawful payment, and had that not happened, my clients would at least be £600 the better, because that money would have stayed in client account and they would have been able to recover it from the clients. So, but that is a solicitor's overhead, my lord, of the sort my lord has been asking about in the question, and it's different from the obligations we're concerned with here. We have to remember that this is in this specialised context of conditional fee agreement, after the event insurance, and a loan from my clients to the lay client in order to fund their disbursement liability. So I don't accept the predicate for my lord's question.
But if your clients are professional lenders providing a service, why shouldn't exclusion 6.6b be just taken at its face?
My lord, the reason for that is they're providing the service to the lay client.
Well,
They're providing the their Consumer Credit Act loans are to the lay client.
But the lay client,
That I accept.
but the lay client's legal rights against Barringtons are fully protected under the policy. Because the compulsory insurance protects the client. You're saying that the compulsory insurance extends to somebody in a very different relationship, the commercial lender providing a service. And why should it be so construed if that's not the natural meaning of 66B?
Well, my first point is, I do say this is the natural.
Well, we've come to
the DFMA is not a contract for services. So I'm with my...
Yes, sure.
But secondly, it is inappropriate to construe that exclusion so widely as to cut down an obligation, albeit owed by a separate contract, which is the equivalent obligation of that owed to the lay client. Because in those circumstances, one is in fact cutting down. This is my...
Maybe, I mean, there may be in practice be from the insurer's point of view, a considerable difference in the exposure, even if they are back-to-back or parallel, to a lot of small clients and to one big organisation like you. You're much more likely to pursue claims.
Not big, my lord, but
right.
We may be. My lord, the prospect of...
Bigger.
Prospects of my clients suing 176 people who've been let down by their solicitors.
Of course.
Who have no money.
Of course, no, we understand that. But the point is that the solicitors have, on your case, exposed their insurers to claims by persons other than clients. Individual clients may not be very likely to pursue claims. There are no doubt statistics about that sort of thing. Whereas you've got a consolidated block of loss arising from lots of little claims or items and are more likely to be a material exposure.
However, my lord, I don't accept that the exposure which is here caused by the breach of duty to the lay client, where one is dealing with hundreds of lay clients with personal injury cases, in terms of the funding of the disbursements, actually does give rise to any issue which my own friend talks about, the extra cost and so on.
Why not, actually? Because if the wider you make compulsory insurance to cover people who aren't clients, why is not the natural effect to increase costs and therefore premiums and therefore costs of legal services to those who are clients?
It could be. It is not on the facts of this case. Because on this case, we have an obligation to discharge the duty to the client, and as I have been submitting, the loss is, to all intents and purposes, less so far as my clients are concerned. It is part of the lay client's loss. The difference would be the loss of opportunity claim which the lay client could have, which is not these cases, my lord. Yes, I accept that in general terms it could increase costs. It doesn't in relation to this particular case, because we are dealing here with a case where impacts interests, albeit to protect their loan, their interests are, to all intents and purposes, the same.
But we can't construe the clause by reference to this particular case. A warranty to A that the solicitor will perform his duties to B does not restrict of itself A's claim to B's loss.
No, well, my lord, the loss that arises here is the loss caused by breach of duty to the lay client. And the question the judge had to grapple with is what those losses were. So it doesn't necessarily amount to the same thing. It so happens. The reason that so happens in this case, my client's loss is likely to be less than that suffered by the lay clients because of the loss of opportunity.
But
in
that's
those
the
rare
point.
cases.
It so happens.
Well, my lord, yes, I'm putting this forward in fact to meet an argument advanced against me, and I haven't yet got to is this a contract for services or not?
Which is a
although
very-
the discussion, if I may say so.
Waiting in eager anticipation.
Yes.
Well, I think, shall we wait until 2 o'clock?
Oh, even longer, my lord.
But we will allow you to get on to that argument at 2 o'clock.
What about?
Thank you.